And does Sean have additional family members that he has contact with?
He's got a brother who lives in Nebraska who was here on Monday but couldn't be here today. He's got another brother that lives in Niceville.
I have no further questions.
To the state?
I don't have any questions.
Thank you, ma'am. Thanks for
Thank
being
you.
here. Please.
If you raise your right hand, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Sir, could you please state your name for
Yeah.
the record?
Michael Wayne Plummer, Plummer.
How do you know Mr. Watson?
I'm Cindy Watson's husband, married her after her husband passed away, and I met Sean very shortly after that. I've known him about 4 years. I find him to be a great character. He's helped out his mom on numerous occasions. He comes over and helps us with anything we might need. I've never known him to be harmful to anyone, least of all animals or people.
And where do you live, sir?
I live at 155 Bermuda Circle Drive North in Niceville, Florida, Blue Water Bay area.
I have no further questions.
Thank you. To the state?
I don't have any questions.
Okay, thank you. Thank you, sir.
And Judge, additionally, there were 2 letters that I was provided this morning. One is from a Krista Sermiak, and there's one from an Andrea Johnson. May I tender those to the court?
Please. Yes, sir.
I have shown as deeds to the state.
Thank
That's
you.
correct.
Thank you. If you'll give me a moment. I want to get somebody out of here so as soon as someone is here. Thank you. Yes, sir, Mr. McGinn.
And Judge, the primary argument for the bond motion is asking for a bond reduction because of the $2 million, $800,000 amount, because Mr. Watson has been unable to make that. Additionally, there is also a side argument in 24 CF 343, which is the case in which Mr. Watson's mom posted a cash bond. Effectively, she's asking the court to allow her to surrender the bond to get the $5,000 back and to set I believe that would be set at a $5,000 cash professional bond if that were to happen. And that would be a side issue to the primary request for a bond reduction in 24 CF 1016. There are a lot of counts in 24 CF 1016, which adds up very quickly. We're asking the court to take that into consideration and lower the bond amounts to a position that Mr. Watson might be able to make so that he can go back into the community. He would be able to be employed. The court's heard testimony related to that. He's got significant ties to the community. He's got a lot of people looking out for him. So I believe all those things are things that go in his favor. And the request to the court would be to lower the bond amounts and allow Ms. Watson's mother to effectively get the $5,000 back with a surrender and keep that bond amount the same.
Okay, thank you. To the state?
Judge, we certainly don't have any objection to Mr. Watson's mother being taken off the cash professional bond or her surrender of that one. However, we don't believe there's been any change in circumstances since the bond hearing he previously had on June 20th. At that point, the court did already lower the bonds from $25 million to $2.5 million on the 1016 case. There has been no material change in circumstances other than perhaps the depositions have been taken, at least some of them, and Investigator Peterson of the Sheriff's Office did indicate that there were hundreds of child sexual abuse materials located on a Note 9 device that were found in the master bedroom on a phone where the defendant lives alone. He does have that second open felony failure to register case with ASA Snell. That's 2 counts on that case. And his score sheet on 1016 alone reflects a presumptive minimum score of 538.05 months. Judge, that's over 44 years. He is already a sex offender. He pled to possession of child sexual abuse materials in 2007. So that's similar to what he's charged with on some of these cases. And in 2008, while in supervision for sexual abuse materials, his supervision was revoked and he was sentenced to 5 years in prison for going to the pool at his apartment complex and having minors there, having a MySpace account when he wasn't supposed to be on the internet, and having adult pornographic materials. We do believe the prior case indicates a strong interest in children, and the VOP violation, as well as the fact he's facing now 9 failure to register charges across 2 active cases, indicate he can't comply with sex offender rules and regulations, and that does make him a danger to the public. So we'd ask the bonds remain set as they are.
Thank you. Mr. McKinney, fine.
Judge, the court can certainly order pretrial services with no access to the internet to comply with all registration requirements. As you look at these 2 cases, the 24 CF 1016 case is a later case number, but the facts actually predate the other case, which is why there was likely not a bond revocation. So as the court looks at the timeline, that would be how those cases interact.
Okay. To the state, no allegations of Mr. Watson traveling to meet anyone, correct?
That's correct.
And not soliciting any minors?
That's correct. But if I may, he did have a number of social media accounts that were unregistered, which is the basis of the failure to registers.
Thank you. Mr. Watson, one of the toughest things to do is, for me anyway, is sentencing on a child pornography case. If a jury finds somebody guilty, and I tell people that off and on whenever they say the difficulties of the job, the other side of that is we see a lot of great people, grandparents that take over for the grandchildren when the mother has substance abuse problems. You know, there's a lot of great things we see, but the toughest thing, I think, is that. And so kind of in that same vein, setting a bond for these materials, everybody says you'd never harm any human or any animal. Well, some minor child's being harmed by what's happening in these videos. And the court needs to protect those folks. You've been in jail since May 1st of this year, so that certainly shows you can't post the bond. If you could, you'd be out. One of the things that also is challenging to the court in its decisions was if you were a multimillionaire, you'd be out. If you had a lot of money, you'd be out. And so the court has to weigh, you know, what's a reasonable bond. And then there's cases that say a bond that the defendant can't make. There's some argument that that may not be a reasonable bond. All those things go into the mix. There has been a substantial change, the court finds, from the last hearing on the bonds. The witnesses that you have are singing from the same sheet of music, very loud and clear and consistently. Based on that, the court does grant your mom's motion to surrender the bond, and that bond will be a $5,000 cash or professional bond.
Judge, that would be in 24 CF 343.
Thank you, sir. Yes, sir. Were there other conditions on the $2 million bond?
There was, Judge. I believe at the last hearing, the state had indicated that there was also going to be in-person pretrial reporting, GPS, no contact with minors, do not be where they congregate, and no internet or internet access.
Okay, thank you. Mr. Watson, I'm going to make all of your bonds in 24 CF 1016 signature bonds. So that means you'll be able to sign out of jail and not post any money for those bonds. You know, it means a lot to the court that you didn't take any actions to go out toward any minors, didn't solicit any minors, but you absolutely can't have any internet access between now and when your case is resolved. Okay? When will I see Mr. Watson next?
Judge, procedurally, we would be requesting a continuance to continue with depositions. So we would come back on the January 13th court date for pretrial.
Yes, ma'am.
And Judge, just to clarify, those pretrial conditions, including no contact with minors and GPS, are still in place?
Absolutely. Yes, ma'am.
Thank you.
Yes, ma'am.
And for clarification, in 24C of 343, is that 5,000 cash professional per count or total?
It was the total before, correct?
My
The
apologies.
$5,000 bond in the other case?
Was
There's two
in,
counts.
is a 2-count.
Was it $2,500 per count?
I'm verifying that right now, Judge.
Okay.
Yes, Judge.
Okay. Thank you.
So it would be $2,500 cash professional in each count.
Yes, sir. Thank you, Mr. Watson. So you'll need to be back here on January 13th at 9 o'clock, okay? Thank you for your family and friends coming. Thank you. Okay. Thank you. Hello, Ms. Dudley.
Good morning, Your Honor.
Good morning, ma'am. Morning,
This
sir.
is Diego Cardona, 20 CF 2812. We were left today for the state to review the case. They still haven't had a chance to look at everything in it. If we could leave it set up, leave for December 9th.
It's the first
Your Honor.
misdemeanor.
And I've also filed a motion to dismiss in this case as well.
Okay, so you intend to file a motion?
I've already filed it. I filed it this morning.
And is the motion what's being heard on December 9th?
It's for status. If they're ready to hear, it's a legal motion, so I don't know if they'll be ready to hear by then or not. It's just a C4 motion. They don't file a traverse, then we will, if they do file a traverse or demur, we can do it.
I wouldn't have a problem setting the motion for like the second week if we can, just to
At
give
the
me
12th?
some time. 12th or the 16th.
Okay, which one do you want?
I want to say the 12th has 2 substantive already on it. Can I just get the 16th?
12, 16? Okay, so still coming back on the 9th for status?
Yes, Your Honor, because we may have a resolution before
Okay.
then, so we want to.
So, Mr. Cardona, I'll see you on December 9th, okay? So that status, December 16th, is a motion hearing, and that will be at 1:30.
Yes, sir.
And then we're continuing the underlying case to January 13th,
Yes, sir.
okay?
You have a
Thank
good
you,
day.
you too.
Your Honor, the next one I have is Deontay Wingate in 23 CF 2775. He is
Yes, sir.
incarcerated, but he is being held in Santa Rosa County. He was picked up on these same charges federally. But he is okay with me going forward on the bond hearing that he has requested. The appearance has been waived in this case.
Okay, yes, ma'am.
Mr. Wingate is asking for his bond to be reinstated. His bond was revoked when he picked up 2 misdemeanor charges. He's not a flight risk at the moment. He is incarcerated in another county. He has no prior failure to appears that the undersigned is aware of. He's amenable to any conditions of bond that the court deems appropriate, including GPS monitor. He is requesting that the original bond be reinstated, or that a reasonable cash or professional bond be set with any conditions the court deems appropriate.
To the state?
Your Honor, the state would object to having this bond reinstated. In addition, like Ms. Dudley stated, he did pick up 2 additional misdemeanor charges. And then after that,
And what were the charges in those cases? Were they drug-related?
I'll have to,
It was a false ID and then put marijuana, and marijuana was dismissed.
Okay, okay,
however,
thank you.
after that, he's since, not only did the federal DEA and marshals pick him up on these particular charges, they also arrested him on additional narcotics distribution charges. So that's in addition to the 2 misdemeanors, and the state would say that's grounds enough to revoke his bond. Anyway, so we would object to having his bonds reinstated.
Okay,
Your Honor,
Mr.
I don't have any information that any additional charges occurred after he was out on bond. So to say that he just because they charge him with those charges, they also charge him with the same charges here. So that doesn't mean he picked up additional charges while out on bond, and that hasn't been shown today. The only thing was a misdemeanor. Like I said, the marijuana charge was dismissed. We would just ask that bond be reinstated in this matter based on that. We don't have any evidence at this point that he picked up any new felonies after he was out on bond in this case. We don't even know the date of those charges. My understanding is that they're from this same incident that he was charged with here. But I haven't been provided, and the state hasn't even said those charges, they're saying he had additional charges came after, occurred after this bond.
Yes, ma'am. Based on Mr. Wingate's charge of providing a false identification to law enforcement, respectfully, the motion to reinstate bond is denied.
Yes, sir. And I believe we are set for January, if I'm correct.
January 13th? Okay.
And I believe that is all I have, Your Honor.
Thanks, Ms.
I think we have pretrial at 12:30? Pretrial detention at 12:30?
We've
Yeah,
got
okay.
12:30 arraignments. Okay, stretch that.
Yes, sir.
12:30
I'll be
is
back then,
pretrial.
Your Honor. Thank you.
Got you, thank you. Okay, private counsel, any other? Nope. Okay,
Your Honor, I have one in the gallery,
please.
Travion Miller. Mr. Miller is present approaching. Your Honor, we are prepared for trial. I believe the state needs to call the witnesses.
Is there a Jamal Pittman or a Percy Pittman? Okay. Your Honor, if we can let the record reflect, the state had subpoenaed both of the victims in this case. We have had an issue getting them to depots. I kind of wanted to put on the record, my office has attempted to contact them multiple times. I actually spoke to one of the victims just a couple of hours before we were scheduled to have a Zoom depot to remind him of the deposition. He did not show for that, neither did the other victim. So at this time, Your Honor, we're going to be null processing this case due to lack of victim cooperation, Your Honor.
Mr. Miller, your case is dismissed. Thank you, sir. Ms. Cashwell, what case do you have?
Yes, Your Honor, I have State of Florida versus Lorraine Lewis, case 21 CF2313.
Yes, ma'am.
And there's a waiver in the file for my client's parents. The reason for the violation of probation has been null processed here in Gambia. I searched Mr. Gomez. My understanding is he was then dismissed with VOP.
That's correct, Your Honor. Due to the underlying new law being the basis for this VOP being dismissed, the state's going to announce a dismissal of this VOP at this time and reinstating to complete the original terms of probation, Your Honor.
Okay. Mr. Lewis's VOP is dismissed and his current supervision is reinstated.
Thank you, Your Honor. Have a good day. Have a good Thanksgiving.
Thank you, ma'am. You too, Ms. Cashwell.
All right. Bye-bye.
Okay, well, we've got an empty defense table. Let's see if I... Thank you.
Your Honor, if I may, just to apprise the court of why we're here. We were here for a status date. I believe it was in regards to Ms. Musselwhite getting private counsel, if I'm not mistaken. And so at this time, we're just trying to figure out or ascertain whether or not that private counsel's been obtained.
Thank you. Ms. Musselwhite.
Good morning, Your Honor. I wanted to inform the court that I have hired legal representation through Muska Law. I've spoken with their office just this morning, and we're in the process of finalizing the retainer payment. Unfortunately, due to short notice, they were hard to get a hold of, and they're not able to be here this morning to represent me. However, they do fully plan on representing me moving forward. So I'd like to ask the...
And it's through what?
Muska Law.
Okay. How do you spell
Attorney
it?
Cheryl Gooden
Good, Ms. Gooden, okay.
will be representing me. So I, asked for some guidance on how to move forward, or possibly request a continuance so they can, fully prepare my case.
Okay, to the state, what do you wish to do? Do you want to have another status conference? Do you want...
I wouldn't mind having, I think we need to set it probably for 1/13, but have a status conference sometime in December to ensure that Ms. Gooden has everything that she needs. I'll make a note in the file now that she's obtained Ms. Gooden, so we can get the discovery out in this case to Ms. Gooden, and we
Good.
can have a status conference to make sure that she received all of that and is working on the case.
Okay, so, Ms. Musselwhite, I'm going to set it for a status conference on December 19th at 9 o'clock. That should give you enough time to get everything in order.
I appreciate it.
If Ms. Gooden wants to appear via Zoom at that hearing, that's fine too. If she wants to get a waiver for you, where you don't have to appear, that's fine. If you don't get her on board, then you need to be back here on the 19th, okay? And the underlying case is continued until January 13th, but status conference December 19th at 9 o'clock.
Thank you, Your Honor.
Thank you, ma'am. Any other pro se's? Okay, thank you. Mr. Koch, are you ready?
Yes, Your Honor.
Folks in the gallery or
Yes,
the
Your
lady
Honor.
on Zoom?
If we could first call Ms. Elizabeth Ruger in 23 CF 2799.
Hello, Ms. Ruger.
Who's present and approaching, Your Honor. Your Honor, my client wishes to move forward with trial.
Okay. The state ready for trial on Ms. Ruger's case?
So, I believe so.
Good.
There's, I may have an issue with an expert with FDLE. I'm trying to finalize that, but I believe we're ready. Aside
Okay.
from that, so.
What day are you going to try Ms. Ruger's case?
Just that, during that week or the second week. is the
Well,
trial.
but I mean, we're not, unless we're going to come back next Thursday, we're not going to have any hearing dates between now and then, and Ms. Ruger needs to know when the trial is. I need to know for scheduling of other trials later today.
And
Is it a one-day trial?
and Judge, next Thursday is Thanksgiving.
Not next week, the week after, December 2nd. Thank you. Ms. Ruger, I don't think anybody was talking about going to trial next week. Yes, sir.
Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
So, Ms. Ruger, we were just talking about scheduling, so I'm setting a motion hearing in your case for Tuesday, December 3rd at 9 o'clock. Mr. Koch has filed a motion, so I'll hear that then. Do you still want to just pass on Ms. Ruger's case, or do you just want to let her know later what day of the week it'll be? Okay. So Ms. Ruger, then we're looking at going to trial at the end of the week of December 2nd. The state will be talking to their witness to figure out when that witness is available. Mr. Koch will stay in touch with you. I told them I've got to know when it's going to trial no later than Wednesday of next week, because I've got to let jury management know how many we need for that. So they'll let all of us know before the middle of next week when the trial's going, but I'll see you back here Tuesday, December 3rd at 9 o'clock, okay?
Yes, Your Honor.
Thank you, ma'am.
December 3rd, I'll contact you on the trial date, all right? Yes, ma'am.
But give me a minute on that.
And then, Judge, if I may call, Alyssa Peterson is on the virtual link, Your Honor.
Okay, yes, sir.
All right, there's a VOP, I'll wait. Ms. Peterson, if you could unmute and turn on your video, please.
Oh, got it. Okay, thank you, ma'am. Thanks. Ms. Peterson, if you'll please turn on your microphone and also your camera. Ms. Alyssa Peterson, there you go, good.
One second, let me figure out how to do this.
Okay, let's see if I can help you by asking you.
Okay, 1 second.
Okay,
Back. Sorry. Just trying to figure.
okay.
Okay, start ready. There we go. Got it. Sorry about that.
No, ma'am, now we can see you. Thank you, ma'am.
Awesome.
Okay, Mr. Koch?
Your Honor, I checked with probations this morning, and just to kind of fill in the state, my client has not paid anything towards that restitution number that we discussed.
Okay.
Mr. Gomez, could you please state the current offer? Knowing that the restitution nothing's been changed.
I'll give an offer at a later date, because I was waiting on if she was gonna pay. She represented to this court that she has money, but that she tried to use $1,000 to bargain us to make some sort of deal. So she obviously has money. It's not going to be a deal that's in her favor, since she wants to play games with not paying the money that she has. So it's likely gonna be an incarcerative sentence.
Okay. So continue it until January 13th?
It's a VOP, Your Honor.
Okay, when do you want the evidentiary here?
I would do any date in December, whatever one Mr. Koch wants to do.
December 12th, December 16th?
Judge, if I just may ask my client, I believe she's out of town, I just want to make sure.
Sure.
Ms. Peterson, if you could hear clearly, the state attorney's office is going to give us a firm offer, but it will be an incarceration sentence. So this court, we're going to set this for an evidentiary hearing, and I believe Judge Brown.
I don't know how to get it. Our incarcerated, you're gonna have no money.
One sec, Ms. Peterson, please don't make statements. What I'm asking you is what date works best for you? Judge Brown, I believe said, we got January 9th.
No, December 12th or December 16th?
December 12th or December 16th, where you have to be present in person in Okaloosa County.
December, you said 16th or?
The
No.
12th.
Yes, ma'am.
Sorry, Judge.
I don't have to buy a ticket, so I have to see. All right, look, I don't know right now, because I don't know my money situation, but I have money to buy a ticket to go out there. I'll have to figure out how much it's gonna cost me for a ticket, so can I get back with you with the ticket prices and how many, the prices to get out there, because,
Judge,
you know,
Oh, sorry.
Ms. Peterson, I'm going to set your VOP evidentiary hearing. It's basically like a judge trial. I'm setting it for December 16th at 1:30.
At 1:30,
Yes, ma'am.
and I have to be present for it.
You have to be here physically. Yes, ma'am.
Okay, 1:30, December 16th.
Yes, ma'am. Thank you, Ms. Peterson.
And
Thank you.
before you log off, Ms. Peterson, can you please call today and schedule an appointment to talk to me on the telephone, a telephone conference? Do you have my number?
Yes, I do, I'll do it right now.
Yes, ma'am. Thank you.
Thank you.
Thank you, ma'am.
Thank you.
Judge, if we may call Ms. Michelle Stoudemire, who's approaching.
Yes, sir. Hello, Ms. Stoudemire. Good morning.
Your Honor, this will be a change of plea this morning.
Yes, sir.
And we're here in 24 CF 1475. Ultimately, count 1 is going to be no pros. Count 2 will be adjudication of guilt, credit for time served. This will be misdemeanor court costs, and then there's 150 in defense costs, Your Honor. If I may approach with the plea form.
Yes, sir. Thank you. Ms. Stoudemire, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You can put your hand down. Ms. Stoudemire, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you sign it?
Yes, sir.
Ms. Stoudemire, I do accept your plea. Count 1 is dismissed. You're adjudicated guilty of count 2. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. How long will it take you to pay those amounts?
If I can at least have like 3 months with the
Why don't we do
holidays.
6 months, okay?
Okay, that'll
Okay.
work.
So if you fail to pay them within 6 months from today, they'll go to a civil lien or judgment.
Yes, sir.
Thank you, ma'am. Good luck to you, ma'am.
You're welcome. I believe that is Ms. Joyce Richmond on the virtual. I know it's listed as Angela.
That might be mine.
Is that yours?
Actually, I think that's Mr. Bitchcott.
Judge, that's all I had present in the courtroom then.
Okay, to Angela, who's on Zoom, if you'll unmute your microphone and start your video. Angela, we can't see you, but there you go. Now we can.
Hi.
Thank you. Yes, ma'am. What's your last name?
Wanless.
Judge,
Thanks,
this is
Ms.
Angela Wanless. This is my client, 24 CF 1617. This was set as a plea or continue with the CAC. So today we're asking for a continuance. We left it set today to go ahead and get the depositions rescheduled. They are scheduled on the 13th of December. And I'm certainly working with the state and trying to make sure we have all of the discovery materials and that we're able to get good service on the 2 juveniles who are the witnesses we need to talk to move the case forward.
Okay. Ms. Wanless, so you'll need to be back in court on January 13th at 9 o'clock, okay?
Yes, sir.
Stay in touch with Mr. McKinney. We're changing judges, so Judge Stone is taking over this division starting in January. Does he allow folks to appear via Zoom? Good. The clerk's saying yes, because I thought I'd heard somewhere that he required everybody to be here live, so I'm glad that's not accurate.
And Judge, Ms. Wanless stays in good communication with me. She was going to have to walk to the courthouse today, which is why she's appearing via Zoom.
Okay. Thank you, Ms. Wanless. So January 13th at 9.
At 9?
Yes, ma'am.
Yes, sir.
Thank you.
Mm-hmm.
Okay. Mr. Koch? Oh, good. Yes, sir. Come on up.
Thank you. Good lunch.
Good, Mr.
John
Barnes.
Muldoon. Thank you. Good morning, Judge.
Good morning, sir.
Mr. Barnes, good to see you. Mr. Muldoon is coming along, Judge. We've got the new law violation in Escambia County. Believe it or not, it hasn't even reached the docket day yet, but that will occur on the 26th, next Tuesday. The presumptive jury trial would be, 2 weeks from Monday, this coming Monday. Sorry, I don't have the date committed. or the following Monday, because it's a 2-week cycle, if we get reached this cycle. But we had a child hearsay hearing yesterday, and by all accounts, we're headed towards the disposition by way of a trial.
Okay, so do you want to have the hearing back here on December 19th, or do you want to do it next year?
When you say the hearing, and I'm sorry, because I'm a little...
Whether you want to do it with or without subpoenas, the VOP hearing?
Yeah, could we do December 19th without?
Yes, sir.
And then, obviously...
If it's not resolved then we'll set it for one with.
Yes, sir.
Okay. So basically a status conference?
Yes, sir.
Okay. Or a VOP non-evidentiary. So Mr. Muldoon, you'll need to be back here on December 19th at 9 o'clock. Since it's just that kind of hearing, if y'all want to attend via Zoom, that's fine with the court.
Yes, sir. Thank you very much.
Thanks, y'all.
Thank you.
Yes, sir. Mr. McKinney, you're the only attorney in the court.
Mr. Hodge went to the third floor just to see if anybody was there.
Judge, I have Mr. Tarver.
Hello, Mr. Tarver.
Mr. Tarver is present before the court. And Judge, this is going to be a PTI. We're going to need a control date, but it's a PTI with a plea, which Mr. Tarver has reviewed the plea agreement that would effectively come into play if he were returned to the docket. If that were the case, then this is a third-degree felony, and the sentence would be totally up to the court. Today is 11/24.
Hello, Mr. Tarver.
Good morning, sir.
Good morning. If you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. So, Mr. Tarver, did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Absolutely.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So, Mr. Tarver, if you successfully complete pretrial intervention, please, what happens to your underlying case?
Everything goes away?
Right, it's dismissed, so it's gone. So it's worth your time and effort to do that, right?
Yes, sir.
What happens if you don't fulfill pretrial intervention? Then what happens to your case?
It reopens.
And you're waiving your right to a jury trial, and then we go straight to sentencing. Do you understand that?
Yes, sir.
Okay. Any questions for me or Mr. McKinney or the state?
No, sir.
Okay. Mr. Tarver, I do accept your plea. I wish you the best in pretrial. Make it through that, okay?
Yes, sir.
Thank you, sir.
And Judge, if we could have a control date, I'm handing him the paperwork for PTI right now. It should fall off the docket.
January 13th? Good. Thank you. By the way, I read an appellate case that I saw in the last day or two that was one of my cases where, well, that's not true. It was one that went up on a 3.850, and they quoted, and it wasn't the court, but staff attorneys quoted the transcript of asking about, the coerced or into the plea and saying, do you understand that you could be sentenced up to this? And those longer colloquies really help. So we'll see what the appellate court says, but I was glad that at least I did it in that instance.
Yes, sir.
Yes, ma'am.
Ian Wilson? Yes.
Thank you.
He's under Glenn Switek and Mr. McLean.
Okay, thank you.
And Judge, I've been in contact with Mr. Switek. He's in Defuniak this morning.
Okay.
And he has no issue with me going ahead and handling this case for Mr. Wilson.
Okay.
We both represent him over a number of cases. This is not on the trial docket. I met at length with Mr. Wilson yesterday. In the plea or continue stance of the case, we're asking for the continuance until January 13th for the next pretrial. I believe that we are where we need to be with the state. We need to communicate with the state related to a plea agreement. So Your Honor may see Mr. Wilson prior to the 113 pretrial.
Okay, good, Mr. Wilson. I hope that the state offers you something that you want to accept. If not, then you'll be back here in front of Judge Stone on January 13th. But if the state does offer you something that you want to accept before that date, Mr. McKinney can set it for a hearing.
Yes, sir. Thank you.
Thank you, sir.
And Judge, I may have one additional show up via Zoom.
Okay, and I've still got it on, I
Okay,
just
just making
don't
sure.
have the monitor. Yes, sir.
Your Honor, I have Hui Win in 23 CF 2595.
Yes, sir.
Your Honor, this time Mr. Wynn is going to enter a plea to resolve this case. This plea will be no contest as charged on counts 1, 8, and 9. Counts 2 through 7 are being no pros. The agreed upon disposition is that Mr. Wynn, on count 9, that is a first-degree misdemeanor, there would be an adjudication on that count alone, and he would be sentenced to credit for time served. On counts 1 and 8, those are both third-degree felonies. Mr. Wynn will be placed on 18 months of probation, concurrent between those counts. Special conditions of supervision are that he will attend and complete a substance abuse evaluation and any recommended follow-up treatment, perform 24 hours of community service. He will be assessed $615 in court costs, $150 in public defender fees, and there would be a withhold of adjudication on counts 1 and 8. I'm sorry, 1 and 8, I'm sorry.
Okay, and he'd pay $40 per month cost of supervision.
Yes, sir. May I approach?
Yes, sir. Mr. Wynn, if you'll raise your right hand, thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand down. Mr. Wynn, did you read the plea agreement?
Yes, sir, I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir, very.
Did you sign the plea agreement?
Yes, sir.
Mr. Wynn, I do accept your plea. Counts 2 through 7 inclusive are dismissed. You're adjudicated guilty in count 9. You're sentenced to credit for time served. Counts 1 and 8, adjudication is withheld. You're sentenced to 18 months probation. That's to run concurrently, run at the same time. You'll need to pay the $40 per month cost of supervision. The court costs $150 public defender's fee. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You'll also need to perform 24 hours of community service work. Thank you, Mr. Wynn. Good luck to you, sir.
Thank you, sir, I appreciate it.
Yes, sir.
Yeah, thank you.
Your Honor, next in the gallery, I have Raheem Miller.
Thank you. Hello, Mr. Miller.
Your Honor, this is Mr. Miller in 23 CF 1598. Mr. Gomez is about to put a signature on a plea. This is going to be a plea to the bench. The specific terms, Your Honor, are that count 1 is going to be null prost. That would leave for sentencing counts 2, 3, and 4. Those are 2 third-degree felonies and a first-degree misdemeanor. Mr. Miller does currently score just south of 20 months in the Department of Corrections once that count 1 is dismissed. The state is agreeing that there will be a 30-month cap on any DOC incarceration. There was no cap on any potential length of supervision which may be imposed. We are going to be asking the court to consider withholding adjudication at this sentencing hearing. So that's why the discretion of the court is checked on the adjudication of guilt. And I did talk to Mr. Miller, and he's going to request that a pre-sentence investigation be prepared.
Okay, good.
May I
Thank you.
approach?
Yes, sir.
I don't have a score sheet just because it's not sentencing right now. We are going to ask the court to set off sentencing. I would propose, and it's a little tricky because Your Honor's taking the plea and then leaving the bench. So I think Your Honor would be the one sentencing Mr. Miller.
Right.
But I don't want to put him on like December 19th. I mean, we're asking for a pre-sentence investigation report here. So I'll leave it to the court to look at your calendar, Your Honor's calendar. I know Mr. Miller would prefer a date later in January.
Okay, to probation with Thanksgiving, any way to do a pre-sentence investigation and have it completed by December 15th or 16th?
Your Honor, that wouldn't give us enough time. There's going to be office closures, and we're not going to have enough time.
Okay. What I will do is I will just jump into Judge Stone's, either I can come before he comes on the bench, or I can do it at lunchtime.
Okay.
Probably lunchtime would be the
We can do that. I don't have Judge Stone's calendar in front of me, so.
Okay, you want it later in January?
Yes, sir, Your Honor.
There are miscellaneous dates in January. There's the first miscellaneous dates, February 13th.
Jeez. Well, could we put it on February 13th?
Yes, sir. Let me double check mine and make sure I'm not.
Unless Madam Clerk sees an additional miscellaneous court date in January.
I do not see any.
That's interesting. Okay.
I have shelters and detentions and domestic violence. Shelters and detentions are at 1.
That's fine. Hey, Scott.
Okay.
What if we try to do?
Rachel's saying just set it as a standalone hearing.
We try to do a Thursday pretrial detention late December. It gives over a month.
My concern is, I'm taking the last week of December off.
Okay.
We already have a number of actual contested hearings on the 19th.
Right.
So, which I think is a Thursday.
Yeah.
So,
Okay.
I mean, we could put it,
I mean, we can do it as a standalone hearing, as Rachel suggests, just on my docket.
The state would prefer like early January.
Okay.
Well, I guess it depends on how early. Hold on.
Do you want to do it on January 10th? That's a Friday in the morning? Or do you want to do it January 13th? That's a Monday? Or
So January 13th is our first pretrial date in January. And
January 14th?
what about January 22nd? Does Your Honor have anything on that day?
That's my juvenile delinquency date.
Can you pull that down?
And shelters and detentions. Can you do it the week before, the 15th?
If I'm not mistaken, the way that Judge Stone has pretrial set, we're in pretrial.
That's
on
our
the 15th.
in custody.
He's got 2 different days.
Yes. What about January 17th? That's a Friday.
I'd be okay with that.
Okay, I can't do it that day. Why don't we do it on January 22nd? You just tell me when
We can do that.
you want to do it.
Can we do it in the morning?
Sure?
Do it 9 o'clock.
9
I don't have
o'clock?
anything on my calendar. 9 o'clock would be fine.
Okay. And how long do we think it'll take?
Maybe half an hour?
Yeah, I can't see
Okay.
longer than that.
Okay, so 9 o'clock on January 22nd.
All right, man.
So, Mr. Nguyen, I'll see you then, okay? January 22nd at 9 o'clock. You'll have to find my name somewhere. It may even say juvenile delinquencies, but just go wherever you see my name. Okay, thank you. Okay, yes, ma'am. Rachel, who's next?
Jeremy Ross.
Thank you. Hello, Mr. Ross.
Judge, can I have a moment?
Sir. Read it.
Thank you, Your Honor. This is Mr. Jeremy Ross in 2024 CF 1756. We'll also be addressing my client's new law misdemeanor, which is 2024 MM 3921. In the 24 CF 1756, this will be an omission. We'll be maintaining the withhold of adjudication, be reinstated. There'll be the $100 cost of prosecution, ultimately $250 in defense costs, and to complete all the original requirements. The 24 MM 3921, it'll be adjudication of guilt, credit for time served, and court costs. If I may approach the plea form.
Yes, sir. Good, thank you. Mr. Ross, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, my honor.
Thank you, sir. You can put your hand down. Mr. Ross, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir, I did.
Did he answer all of your questions?
Yes, sir, he did.
Are you satisfied with his representation?
Very.
Good. Did you sign the plea agreement?
Yes, sir, I did.
Mr. Ross, I do accept your plea. In the misdemeanor case, you're adjudicated guilty. You're sentenced to time served. You'll need to pay the court costs, and we'll come back and talk about that. And there's a $150 public defender's fee. There's a total of $250 public defender's fee in both cases. In the felony case, it's a withhold of adjudication. Your current supervision is reinstated with all the original terms and conditions. You'll need to pay the $100 cost of prosecution, and again, the $250 public defender's fee. As far as the cost, the court costs in the misdemeanor case, Mr. Koch, how do you want those?
Could we put that with the cost of the probation, Judge?
Yes, sir. So, Mr. Ross, you can pay those court costs during your probation in your felony case.
Okay, thank you.
Okay, thank you, sir.
This is Alex Sawyer.
Thank you.
Yeah.
Good morning, Mr. Sawyer. How are you? Yes, sir.
Judge, we were set, at pretrial, it was always set to continue because we had outstanding discovery and offers and score sheets. So this morning I was provided a score sheet from Mr. Snell, so that was satisfied. We had a pending counteroffer that was unfortunately declined. So ultimately I'm asking this to be set on the 113 pretrial.
Okay.
I just want to notate that 24 CF 617 has an outstanding FDLE, so there's probably going to file a motion following up on this just to get that FDLE or address it with the court. And I got the score sheet. I'll be seeing you tomorrow, getting you up to speed. Yes, sir. Okay?
Mr. Sawyer, you'll be back before the court no later than January 13th.
Okay, I've been in jail for like 10 months.
Yes, sir. I will play whatever hand y'all deal me, so if there's any motion that's filed, I'll rule on that motion. Okay?
If there's something I can do, please.
We'll talk to you tomorrow afternoon.
Yes.
All right, Alex.
Thanks, Mr. Ross. I mean Sawyer, I'm sorry. Ma'am?
Benjamin Smith.
Thank you, Smith. Hello, Mr. Smith.
Judge, this is Mr. Smith in 24 CF 111 and 24 CF 1640. Similar situation at pretrial. This was never set for trial. It was some outstanding discovery counters. I want to, or speaking with Mr. Snell, if we can set my client on that December 9th. In that 24 CF 111 case, we've already reviewed the body cam and constitutional suppression issues, so we may be wrapping up everything on that night.
Okay, so a status conference?
Yes, Judge. And just I want to state, I don't have the score sheet as of today, but of course, we may be dropping one of the cases, so, but that's still out in the air.
Mr. Smith, I'll see you on December 9th. Your underlying case, I'm continuing until January 13th, but I'll see you on December 9th.
And I'll see you tomorrow in the afternoon, get you up to speed.
Okay.
All right, Mr. Smith?
All right.
Tomorrow. Yes, sir?
Thank you.
Justin Spillers.
Hello, Mr. Spiller.
This is Mr. Spillers in 23 CF 2689, Your Honor. At this time, the offer was a Phoenix house, so certainly I have to get my client evaluated for possibly accepting that. So at this moment, there's not an offer.
Yeah, I don't.
I understand. At this time, there's not an offer to get you released today, so I will be entering a denial, Your Honor.
Okay. So when do you want to set Mr. Spiller's case?
Judge, what's the next VOP?
December 9th.
Can we do the 9th?
Yes, sir.
And I'll be out at the jail tomorrow afternoon, and we can talk.
And Mr. Spiller, if you and the state work out a plea agreement, then Mr. Koch can set it for next Wednesday at 12:30. Okay? So, but I'll see you no later than December 9th at 9 o'clock.
Absolutely.
Thank you, sir.
Johnson Morales.
Mr. Koch, that's on any plea that may get your folks out of jail.
Thank you.
Well, Mr. Summerall. Good morning.
Yes, Your Honor. This is Summerall on 24 CF 1031. Similar situation. During the week, I got with Mr. Snell. We have an offer that my client wants to accept, but we're asking to place it on the December 9th. Give time to the state to give me my score sheet, and also Mr. Summerall just wants to connect at the jail at his prayer. And so December 9th, we can put him down for a status, but it looks like it's going to be a change of plea that day.
Okay. Mr. Summerall, so I'll see you on December 9th. The underlying case is continued until January 13th, but I'll see you on the 9th. Thank you.
Yes, sir.
Allison Smith.
Thank you. Hello, Ms. Snipes.
That's your copy underneath there. Judge, may I have just a brief moment?
Yes.
Okay. You can sign. There, yep. And it is the 21st of November. Thank you, Your Honor. This is Ms. Snipes in 23 CF 1824, 24 CF 1346. And just follow along with me because I'm going to announce the terms. Judge, this will be a change of plea of no contest. In 23 CF 1824, counts 1, counts 2, and in 24 CF 1346, count 1, be adjudication of guilt, 15.45 months, Department of Corrections, credit for time served. There's 615 in court costs. There's 100 for the VOP cost of prosecution, total of 250 defense costs. Probation will be revoked and terminated. All cases and counts are run concurrent. In 23 CF 1824, count 3, adjudication of guilt and credit for time served. If I may approach with the plea form and score sheet.
Yes, sir.
This is a guideline.
Thank you. Thank you. Ms. Snipes, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. You can put your hand down. Ms. Snipes, are you currently under the influence of any drugs, alcohol, or medication? Have you ever been treated for any mental illness or emotional disturbance Or are you suffering from any of those at this time? You ever had any mental conditions? Okay. Are you currently prescribed any medications for that?
No.
Okay, okay. Ms. Snipes, because of that, tell me what's the sentence going to be? Just basically, what are you going to be sentenced to if the court accepts your plea?
15.4 months.
Okay, where?
Department of Corrections.
Okay. Ms. Snipes, how far did you go in school?
I got my GED.
Good. I know that's self-motivated. Congratulations.
Thanks.
Did you read the plea agreement?
I did.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
I did. Yes.
Has anyone forced, threatened, or coerced you into entering the plea?
No.
Has anyone promised you anything other than what's in the plea agreement?
No.
Okay. Ms. Snipes, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel. Are you satisfied with Mr. Koch's representation? Are you satisfied? Okay. Of when you state you are satisfied, I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty in each case and count. You're sentenced to credit for time served in count 3 of 23 CF 1824. In the other counts, you're adjudicated guilty. You're sentenced to 15.45 months with the Department of Corrections. That's to run concurrently, run at the same time between each of those counts. Also with credit for all time served. You'll need to pay the court costs in the new case, $100 VOP fee in the VOP case, total of $250 public defender's fee. Your current supervision is revoked and terminated. Ms. Snipes, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes.
Thank you, Ms. Snipes. Good luck to you, ma'am.
Thank you.
Thank you.
Is there a time to pay?
Let's just, Mr. Koch?
Yes.
Does Ms. Snipes want a period of time to pay those costs after she gets out?
Could we get 6 months after her release from
Yes, sir.
incarceration?
Thank you.
Thank you, Judge. And Judge, if I have a moment, I have a client that
Yes, sir.
showed up. Thank
Good.
you.
Yes, sir. Thank you.
Your Honor, Mr. Barnett is present and approaching. I'm actually in the middle of composing an email to Mr. Gomez to fill him in on the backstory of Mr. Barnett's cases here. If we could pass him to the 2:30 docket, I'm trying to get hopefully a resolution today, but
Okay.
I can't guarantee it, but I'm working.
Mr. Barnett, I'll see you at 2:30.
Yes, sir, thank you.
Thank you. So if you'll hold Mr. Barnett. Thank you.
David Lanier.
Hello, Mr. Lanier.
Your Honor, Mr. Lanier is signing a plea agreement to resolve 23 CF 884. Today's 11/21. At this time, Mr. Lanier is going to enter a no contest plea on counts 1 and 3. In exchange for that plea, counts 2 and 4 are going to be no prost. This is going to be a DOC sentence followed by probation, but I have to announce it a specific way based on the length of the sentences here. So count 3, Your Honor, is a third-degree felony. On that count, Mr. Lanier is going to be sentenced to 36 months in the Department of Corrections with credit for all time served. Count 1 is a second-degree felony. On that count, he's going to be sentenced to 6 years of sex offender probation consecutive to the 36 months in count 3. So the intent of the parties here is 36 months in prison, followed by 6 years of sex offender probation. Special conditions of that, Your Honor, are that Mr. Lanier will be designated as a sex offender. He will have to wear a GPS monitor at $1 a day while on supervision. He will have no contact with minors, no internet-capable devices or internet access. There would be $615 in court costs, $150 in public defender fees. Mr. Lanier would be adjudicated. Kind of circling back to that no internet-capable devices, I did talk with Ms. Barrickman and I did talk with Mr. Lanier. Mr. Lanier works as a painter, and so he inquired of the state, I kind of use the internet for my business, and Ms. Barrickman informed Mr. Lanier essentially through me that there is a process he can go through to move the court to grant him internet access in limited situations. He does have to go through the risk assessment as part of sex offender probation. He would have to talk to probation about that, and if he wants, he would have to file a motion to the court. But we did talk about that, and so Mr. Lanier is aware of what he would need to do to make that happen. But until that happens, there's no internet access or having devices capable of internet access. And furthermore, Ms. Barrickman informed me, I did not know this, apparently probation has some kind of a old school flip phone that they can authorize people to have that's just a phone. So Mr. Lanier is aware of how to make all that happen. But I did want to be kind of clear on the record for his
Thank you.
benefit.
Thank you, sir.
May I approach?
Yes, sir. Mr. Lanier, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Oh, and I forgot to add it. It's on the written plea agreement, Your Honor, but one of the special conditions of supervision is that he will complete the ECLC aftercare program. He's set to graduate from that program on December 4th.
Yes, sir.
Excellent.
So-
Good. Thank you. Okay, so this is a downward departure.
Yes, Judge, by a few months, we did take the ECLC into consideration when allowing him to enter this plea.
Okay. Mr. Lanier, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
11th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Absolutely.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Lanier, has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what's in the written plea agreement?
No, sir.
Mr. Lanier, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. Counts 2 and 4 are dismissed. Count 1 and 3. Well, let me go with count 3. Count 3, you're sentenced to 36 months with the Department of Corrections with credit for all time served. And that's followed by count 1 is 6 years of sex offender probation, which is consecutive to the time in your prison. You will be designated as a sex offender, wear a GPS monitor at $1 per day. While on probation, you'll have no contact with any minors, no internet-capable devices, or internet access. You will need to complete the EC, and I didn't write it down.
LC.
Thank you, ECLC program. You'll need to pay the court costs, $150 public defender's fee. You'll need to pay those during your probation. Mr. Lanier, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Lanier.
Jeremiah Lovejoy.
Your Honor,
Yes.
this is Mr. Jeremiah Lovejoy. We did reach a resolution here to resolve this case. At this time, Mr. Lovejoy would enter a no contest plea on count 2, aggravated assault by threat. In exchange for the plea, count 1 would be dismissed. The agreed upon disposition is that Mr. Lovejoy would be sentenced to 15.6 months in the Department of Corrections. The state is going to stipulate that that entire sentence has been served. He would be assessed $967 in court costs, $150 in public defender fees, and he's previously been adjudicated. May I approach?
Yes, sir. Mr. Lovejoy, if you'll raise your right hand. Thank you. Do you, your other right hand, there you go. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
So help you God.
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Lovejoy, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Lovejoy, I do accept your plea. You're adjudicated guilty of count 2. Count 1 is dismissed. You're sentenced to 15.6 months with the Department of Corrections with credit for all time served, and the state stipulates that you've served all of that time. You will need to pay the court costs, $150 public defender's fee. How long will you need to pay those amounts?
I don't know. I got to get a job first.
Okay.
but,
Would the court,
yeah.
given the fact that he's been in custody since July of 2023, would the court consider 12 months?
Yes, sir. So, Mr. Lovejoy, if you don't pay those amounts within 1 year from today, then they'll go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, sir.
All right, thank you.
Eric O'Malley's next, he's also on the 230 docket.
Thank you.
He's on 9 as well.
Hello, Mr. O'Malley.
How you doing today?
Good, how are you?
Everything in paradise.
Yes, sir.
So,
I used to look after of cancer or chronic neurological illness. What's the top of it that?
Absolutely, yeah. Let me get this.
Mr. Owens, I'll call you right after this case with
Go ahead, son.
Mr. Kleins.
Your Honor, Mr. O'Malley, he was just inquiring, he thought he was going to be fined $15,000. So, I was telling him.
Almost didn't sign the deal.
I was telling him I wouldn't have signed that either, but I explained it to him. So he is going to be entering a plea to resolve this. Your Honor, today is 11/21. Today, Mr. O'Malley is going to be entering a plea, 11/24, it's 24, of no contest on count 1. Count 2 is going to be dismissed. Mr. O'Malley is going to be sentenced to 9 months in the Okaloosa County Jail with credit for all time served. He would be assessed, I believe, $615 in court costs, $150 in public defender fees. He's previously been adjudicated.
Thank you.
May I approach?
Yes, sir. Mr. O'Malley?
Mr. O'Malley is on the 230 docket for a bond hearing. We'll obviously withdraw that motion.
Okay. Mr. O'Malley, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. O'Malley, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So this is a downward departure?
It is, Your Honor.
Okay. Mr. O'Malley, I do accept your plea. Count 2 is dismissed. You're adjudicated guilty on count 1. You're sentenced to 9 months in the Okaloosa County Jail with credit for all time served. You'll need to pay the court costs, $150 public defender's fee. How long will you need to pay that after you get out of jail?
After I get out?
Yes, sir.
For a favor, give me 6 months.
Yes, sir, you got it. Thank you, sir.
I appreciate it. And what happens if I don't?
Then it goes to a civil lien or judgment. If you get down to about the 5-month
Just
mark,
making sure you only get yanked me back from wherever I'm at.
no, sir, it's civil, not criminal.
All right,
Thank you.
God bless you. Yeah,
Thank you, sir. You too. Mr. Owens?
Judge, good morning. I have Seth Laviolette.
Yes, sir.
Judge, the state attorney and I have been in negotiations, and they proposed a plea offer that's acceptable with some conditions that we've got to discuss. My client lives out of state, and I'd like to set it for a court date that he could potentially plead in abstention.
So is it going to be a misdemeanor?
No, Your Honor.
That's up to
Okay,
you.
when you say an abstention, can he appear via Zoom?
Yes.
Okay. So then he'd still be present. So as long as I can see him and swear him in and talk to him, then we can do that. Do you want to set out the status conference for it on December 9th, December 12th, December 16th?
What's best for me? Whatever's best for.
When will it
do
be
the
in
9th.
place? Sir,
Do the 9th, yeah.
Okay. So Mr. Laviolette's case is set for December 9th at 9 o'clock. And then the underlying case is continued until January 13th. Hopefully it'll be resolved on December 9th.
Thank you, Judge.
Thank you, Mr. Owens. Good seeing you, sir.
You too.
Thank you.
Bye-bye.
Okay, who's next?
Yes, Judge, if I may call Mr. Charles Reyes Jr. He's
Sure.
present and approaching.
Mr. Reyes.
And this is in 24 CF 1839. This is set for trial or plea this morning, Your Honor.
Yes, sir.
I have an offer, went over the plea form, my client, and we're going to be accepting the plea offer this morning, Your Honor.
Okay.
It's enter a no contest plea. Count 1 is going to be no pros. Count 2 be a withhold of adjudication, $615 in court costs, $150 defense costs. Count 3, adjudication of guilt and credit for time served, Your Honor. If I may approach with the plea form.
Yes, sir. Thank you. Mr. Reyes, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Reyes, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Reyes, I do accept your plea. Count 1 is dismissed. Withhold of adjudication on count 2. Adjudicated guilty on count 3. Time served on count 3. You'll just need to pay the court costs, $150 public defender's fee. How long will you need to pay that?
Can you give me 6 months?
Yes, sir, you've got it. Thank you, sir. Good luck to you.
Cool. Free to go, sir. Thank you. You're welcome.
Rachel?
I have 1:30 and 8.
Okay, why don't we let's take a 10-minute recess and then we'll come back and do that. We're in recess for 10 minutes. Thank you.
All right.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Your Honor, that's ASA Snell's case, and I'm not quite sure
Okay,
what
well,
to do
just
that
before we leave, my JA said that would be nice to know, and I started laughing. 'Cause
Yes, Judge.
we certainly need that. We had somebody on Zoom, but they disappeared. Okay, Rachel, you got the docket.
We can do Mr. Purnell on the 130 docket.
Okay.
Dude's wild.
This is Mr. Purnell in 24 CF 2414. Can I briefly ask?
Yes, sir.
Judge?
Yes, sir.
My client does have another case in front of you, and Ms. Dudley is his attorney on that. My client, I believe, they're working out a payment so she can take over this case.
Okay.
But currently this morning, I am his attorney
All right.
currently. I just want to make the court aware of that.
Okay.
So for today, I informed the court that it looks like you've already hit Ms. Dudley, but I'll be entering the not guilty, waive formal reading, and request it be kept on that 113 docket with Judge Stone. I'm going to write this on this so you can tell Ms. Dudley, and I know she's aware of it, but this is your next court date, the 113, okay? And if for some reason it doesn't come through, I'm still assigned and I'll come talk to you, but I just want to make the court aware of that.
Good. Mr. Burnell, that means that and so you were given the information?
Yes, Judge.
You're waiving that?
Yes, Judge.
Okay. Mr. Burnell, that means that you'll be in court on this case no later than January 13th, okay?
Yes, sir.
Thank you, sir.
Thank you.
James McQuaid, Mr. Klein.
And Mr. Vishkan, once Mr. McKinney comes back in the courtroom, we'll take your case.
Thank you, Your Honor.
Yes, sir. Thank you.
Your Honor, this is Mr. James McQuaid in 24 CF 2440. We are in receipt of a two-count information. We'll waive the formal reading, enter a not guilty plea. I just talked with Mr. McQuaid. He's requesting that I file a real quick bond motion for Mr. McQuaid, which I just talked to Mr. Gomez and told him I can write that up in about 2 seconds. If we could pass Mr. McQuaid to the 2:30 docket.
Okay. Mr. McQuaid, I'll see you at 2:30. Thank you. Okay, thank you. Hello, Mr. Kelly. Mr. Kelly's case number is 24 CF 2549. Mr. Kelly, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you average making per month?
0.
How long have you been unemployed?
Like 2 years.
Okay, I do appoint the public defender. Mr. Koch is approaching on your right.
Yes, Your Honor. The grand theft case, if I may, is there a possible offer?
No, there's not. We need to speak with the victim regarding the restitution amount.
Yes, sir. Without an offer this morning, we'll be entering a not guilty and waive formal reading, Your Honor, and request to be kept on that 113 docket.
Okay. Mr. Kelly, you'll be in court no later than January 13th, but if the state offers you something that you want to accept before that date, Mr. Koch can set it for next month, okay?
Yes, sir.
Thank you.
Jason,
The last two were 130 are represented by.
Okay. Do we know where Mr. McKinney is?
I'm assuming that because David and Mr. McKinney are missing together, that they're probably discussing
Hatching out something,
some sort
okay.
of case.
Mr. Noakes?
Judge, I've got one that I can wrap up right now, but I still have to talk to Mr. McKinnon, okay, to get, he's gonna tell me if he's gonna accept it or not.
Okay.
But I got Mr. Petit, he is present. Judge, if I may approach.
Yes, sir.
He's not on today's docket. He's not on today's docket.
Yes, Petit,
Okay.
Monday, remember?
I did see his name recently. Yes, sir.
He called my office the next day.
Excellent.
And,
So, Mr. Petit, the warrant, the capias is withdrawn. Okay.
I can breathe now. Thank you so much.
Yes, sir.
Judge, and I didn't make it. I might have another copy.
That's okay. Let me just read through it.
Okay.
Can I be reminded of the case numbers, Your Honor?
23 CF 813, 23 CF 881.
Thank you.
Okay. Mr. Petit, did I swear you in?
No, sir.
Nope. If you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand out. Mr. Petit, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Petit, I do accept your plea. Well, let's talk about, have you ever been adjudicated guilty of a felony before, Mr.
Yes,
Petit?
sir.
Okay. So it's going to be up to the discretion of the court whether you're adjudicated guilty or not. Do you understand that?
Yes, sir.
Okay.
If so, can I, before you impose the
Okay.
sentence, can I speak? Okay.
Yes, sir.
Okay.
Please, go ahead.
Okay. I'm not asking that my license not be suspended for any fun or anything like that. I have a fiance who's not well sometimes. She's here today. And I don't want to be put in a position that I have to get the kids to school, which, well, I have one stepdaughter that's to school, and I have a 4-year-old that's going to start Head Start. I don't want to be put in a position that she's not feeling well, and I have to take the kids to school. You know, the kids got to get to school. You know
Yes,
what I
sir.
mean? So I don't want to be coming back and forth in front of you for driving.
Okay.
If
Yes, sir. I sure don't want you driving if you don't have a license.
So tell, and real quick, just tell the judge real quick, how long your license has been suspended and what efforts you've made to get them reinstated.
I just got my license back with about, I don't remember what month that was but I had to pay a substantial amount of money, fines, old port fine to get them. And I haven't even had them back yet. Yeah.
Okay. Okay, thank you. Okay, you're sentenced to 60 days in the Okaloosa County Jail with credit for all time served. And the state agrees that you've already served all of that time. That's to run concurrently, run at the same time between each case and count. The court costs are imposed. The public assistance fees are imposed. That's a total of $250. Okay. Now, as far as adjudication to the state, why should Mr. Petit be adjudicated guilty if you're arguing that?
Doesn't he have to be adjudicated guilty if we're giving him a credit for time served offer? We're not doing it as a condition of probation.
There's a misdemeanor in there.
But isn't it a credit for time served offer, so he has to be adjudicated?
I don't know.
We're not agreeing to this as like a condition
Right,
of
I've never had a
probation.
withhold and sentence somebody to jail.
I thought the agreement between the parties was adjudication of guilt, credit for time served. That's what I sent to Mr. Knapp's, I believe.
So Judge, the possession of a controlled substance in the first case number, which is 813, you could withhold on that one, adjudicate him on the paraphernalia, and that covers that question. I did look, and I've asked 9 attorneys, defense attorneys, does the possession of a controlled substance into a prison or jail facility, does that trigger, the suspension? They've all told me no. So I even Googled it earlier today.
But Mr. Nopes, your belief is that if Mr. Petit is adjudicated guilty on the felony counts, then that's going to put him back on his driver, that's going to revoke his license?
I know for certain that the possession of controlled substance will revoke his driver's license for a year.
Okay.
I do know that.
And you don't think it will on the contraband?
I don't think it will on the contraband.
Okay. And the misdemeanor, it would not?
Misdemeanor will not.
Okay. So, Madam Clerk, I'm going to have to revise this to make sure that it works. Mr. Petit adjudication is withheld in count 1 of 23 CF 813, and he's sentenced to time served.
It's going to have to be as a condition of probation. You can't withhold.
As a condition of 1 day of probation, and he's already served that time, and probation's automatically terminated. On count 2, of the misdemeanor, he's adjudicated guilty, and that's the time served. I'm sorry, that's the 60 days. The other 2 are 60. Probably the easiest way, and I'm sorry, Madam Clerk, is just say it's 60 days on each count to run concurrently. And in count one, it is as, the 60 days is a condition of 60 days of probation. And the probation's automatically terminated because he's already served the 60 days. So there is no probation past today. You've already served the 60 days, right?
Yes, sir.
Because the state stipulated. Okay. Mr. Petita, hopefully that, because I know it's really difficult to get your license back, and I certainly want you to keep your license.
Thank you, sir.
Thank you, sir. Thanks, Mr. Petita.
Okay.
Now,
Thank
is
you.
the 23 CF 881 a guilty? It is a felony count?
Yes, ma'am, that's entering into the jail? Is that count two?
It's actually count
So
one
there's
of the
two
different cases.
There's two different cases. With
Right. The only one that the 60 days is a condition of probation is count one of 23 CF 813, possession of a controlled substance. And the other two are just 60 days, without any probation.
But they're both adjudicated?
Yes, ma'am.
Okay.
All of them adjudicated.
Yes, sir.
Okay. Thank you, sir. Good luck to
Thank
you.
you,
Yes,
sir.
sir. And congratulations with your fiance. She
you, sir.
smiled when.
Thank you.
Yes, ma'am.
Judge, thank you.
Thank you, ma'am. You too.
Oh, and Your Honor, how much time to pay?
The state amended their offer on Monday.
Okay.
I had a chance to go down to the court for mediation.
And this is on what case?
On Matea McKinney.
Okay. Is
They made a
McKinney?
really, really good offer, and he told me he wanted to pray about it and think about it.
Mr. Petit,
sir.
before you leave, how long do you want to pay the cost before they go to a civil lien, which then, why don't we say 1 year, okay?
Yes, sir, that's fine.
Okay, 1 year.
Yes, sir.
Thank you, sir.
Thank you.
Thank you.
So if I could go see Mr. McKinney.
Okay. Yes, sir. You let me know when you're ready. Okay. Mr. Vishkan?
Yes, Judge.
Thank you.
Mr. Vichgon is on Zoom. And additionally, we have a written plea agreement that would be it's not a plaintiff since he's here, but the court can sign off on it. May I approach with
Yes,
the plea
sir.
agreement?
Is it misdemeanors?
Yes, Your Honor. It's a
Good.
misdemeanor that calls for 6 months of JCS probation
Good.
to a lesser included petty theft, which, Madam Clerk, is 812-14-2A. Special conditions include $91.60 restitution payable to CEFCO at 1600 East John Sims Parkway, 24 hours community service work. He's eligible for buyout, an anti-theft course, $270 misdemeanor court cost, $150 cost of defense, and standard JCS cost of supervision, which is typically $50 a month. May I approach?
Yes, sir. Mr. Vishkan, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Yes, sir. If you'll put your hand down. Mr. Vishkan, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you discuss it with your attorney?
I have.
Did he answer all of your questions?
He did.
Did you sign the plea agreement?
I did.
Mr. Vishkan, I do accept your plea, and so the terms of your supervision with JCS are as set forth in your written plea agreement, okay?
Yes, sir.
Thank you, sir.
All right. You have a good day, Your Honor.
Thank you. You too.
Thank you, Mr. King.
Yes, sir.
I have William Hackett on the 130 docket with Mr. McKinney.
Thank you.
Judge, this is Mr. William Hackett. Mr. Hackett is before the court today in 24 CF 2573. This is for arraignment. We would acknowledge the receipt of a 4-count information, waive its formal reading, and enter a plea of not guilty, and ask for the next available pretrial date, which I believe is going to be the January 13th court date.
Yes, sir. Mr. Hackett, you'll be back in court no later than January 13th. Mr. McKinney will come see you in the jail. If the state offers you something that you want to accept before that date, Mr. McKinney can set it for a hearing, okay?
Yes, sir.
Thank you, sir.
Madam Clerk, can we confirm that his other cases are all tracking on the same date?
Do you have a case number? You might be able to look
It had bounced around between divisions. I just wanted to make sure everything's going to the same place. One second.
I showed 2 other cases, and yes, they would both be on the same date.
Okay, thank you. Thank you, Judge.
Yes, sir.
Sean Tillman.
Thank you. Do we need probation here?
I don't know what Mr. McKinnon is doing with Mr. Wood.
That's true. Good point. Thank you.
And Judge, Mr. Tillman is before the court for arraignment in 24 CF 2443. We would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty. I believe this and another case are already scheduled for the pretrial date in January, and I'd like to keep that date.
Okay, so are both of the cases set for arraignment, or the ones you just traveled?
Only the one on 2443, Your Honor, saw Mr. Tillman last week in 24 CF 2183, and we previously entered a plea of not guilty in that case.
Okay. Mr. Tillman, the court will see you no later than January 13th.
Yes, sir.
Thank you. Okay, Madam Clerk, on the 9 o'clock docket, who have we not covered?
I have several that I could call and file waivers for.
Yes, sir, please.
Angel Taylor in 24 CF 1748. It was not on the trial docket. I did file a waiver. I believe that the state is going to be filing a dismissal on that case, but I would request a continuance until the January court date and ask for a status date on the first available miscellaneous date.
Okay, why do we, if they're going to dismiss it?
I want to
why
hold
do
their
we
feet to the fire, Judge.
I'm sorry?
I want to hold their feet to the fire.
Okay, let's set it for December 12th at 9 o'clock.
Yes, Judge,
Okay?
thank you.
So a status then, and then continue the underlying case.
I'm going to need to do the 9th or the 19th. I'm going to be out on that 12th date.
Okay, 16th, you'll be out on that too?
That's a Monday, correct?
Probably.
Yes.
I'll be back on the 16th.
Okay, so we'll do it on the 16th.
And Judge.
Yes, sir, thank you.
William Watson is on the docket in 22 CF 1064.
Yes, sir.
Your Honor had told him at docket day that he could appear at 2:30 when his motion for statement of particulars is scheduled.
Okay.
I do believe it's anticipated we're going to have a plea at that time, but we would see him at 2:30.
Good. Madam Clerk, on the 9th.
All right, with Mr. Cobb, Daniel Gooden.
Does anyone know where Mr. Cobb is? And I had it down for, it was going to be a competency hearing, I believe. Is Mr. Godwin, is he? Right. Okay, so to the state, will you get in touch with Mr. Cobb and ask him to appear at either 1:30 or 2:30? Thank you. And that's on Godwin. Okay? Yes, ma'am.
Your Honor, on, so we can be clear, on Kareem Mitri in 24 CF 2632, Ms. Dudley informed me that she filed a motion, or I'm sorry, a notice of appearance. Has our office been formally relieved on that case?
Yes, sir, if she's filed a notice of appearance, yes.
Just want to make sure. Thank you.
Okay, I have Joyce Richmond.
Mr. Koch?
If we could just double check she's not on the virtual link.
There's nobody that's waiting in the waiting room.
Unfortunately,
And Ms.
she's not.
Richmond was set for a trial. I don't see Ms. Richmond. What does the state seek? Capias is issued for Ms. Richmond. Because it was set for trial, it's a no bond capias.
Yes, Your Honor.
So everybody's good on 9? Is there somebody in the,
It's still Mr. Nope, fine, it's all 9 o'clock though.
okay. Do you want to go back there and ask him if he wants the hearing now or if he wants to come? Yes, sir.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a
Either
jam,
one,
please give us
whatever's
a call.
good for him.
We're here to help you out.
It says 5 to 10 minutes.
Okay. Does it, why don't you bring him in? Let's just talk to the attorney first. And
Judge says send us your notes around, please.
While that's all happening, Your Honor, I just emailed a courtesy copy of Mr. McQuaid's bond motion to the court and Mr. Gomez. I got to get a signed one filed, but it's in your inbox.
okay, thank you. And I'm going to hear that when?
I'm going to request to hear it this afternoon at 2:30.
Okay,
It's
Yes,
a
sir.
page-and-a-half document, so.
got it. Thank you.
The Barista took the case.
Cool.
Yeah.
Because I'm paying for this one.
Yeah.
So you're getting them up.
So she got stuck with you.
She's a co-defendant from the court. Doing herself.
Mr. Nopes, does probation need to be here for what you're waiting on?
No.
Okay. Do we want to call your client back at 1:30 or 2:30? Are you going to be here anytime?
I'm done, once I'm done here, Judge. Let me ask you this, could we enter the plea without a plea agreement? Because I'm actually worried that there's not enough room for these 4 different case numbers
Okay.
to put on the plea.
Incarceration or?
Yes, sir, it's 40, I think 49.4 is the score.
49.8 months in the Department of
Yeah.
Corrections with a 3-year minimum mandatory.
No, I'd rather get that in writing.
Sure.
So you want a 10-minute recess, 15?
Judge, I think I can be done in 10 minutes. I'm just going to have to,
Make sure that he has time to read it, okay? Why don't,
we've covered all that, Judge.
Good.
We just didn't get it in writing yet. And so,
okay. So we're in recess for 10 minutes.
Yes, sir.
Thank you.
All right, please.
Can we be excused, Your Honor?
Yes, sir, you can. In probation, you're excused. You want to be back at 12:30, 1:30, 2:30?
1:30.
Absolutely.
1:30, thank you.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident